Welcome to the Arizona Civics Podcast and our series, Understanding State and Local Government, a 10-part mini-lecture series exploring Arizona's history, governance, and civic life. This podcast is designed to provide clear, engaging insights into topics like judicial selection, tribal sovereignty, and direct democracy. Our content expert, Dr. Sean Bienberg, a Phoenix native and scholar of state and federal constitutions, brings deep expertise to this series. Dr. Bienberg serves as the Associate Director of ASU's School of Civic and Economic Thought and Leadership and is the Director of the Center for American Civics. He is also author of Prohibition, the Constitution, and States' Rights, as well as Progressive States' Rights. Let's dive into the systems and stories that shape Arizona's civic life.
So Arizona, like other states, has a branch of the government, which is the judiciary, and which is assigned to effectively implement and apply and interpret the Constitution of both the United States as well as the state constitution. The latter is, in fact, the primary obligation of state judges in Arizona. And so similarly, like you see in the U.S. government, they apply judicial review, in which they determine whether laws that are passed by the state government are consistent with, again, the U.S. Constitution or primarily with the state constitution. So in that, they look quite similar to the federal judiciary. Similarly, the Arizona judiciary has effectively 3 tiers. It's a little more complicated than at the federal model, but for the most part, it uses a similar 3 tiers. There are the lowest courts, which are the superior courts, which are akin to the district courts. There's a middle-level appellate court, which is in some sense equivalent to the circuit courts at the federal level. And finally, there is a Supreme Court of Arizona, just as there is a Supreme Court of the United States. So in that regard, it also looks, again, broadly similar to the United States government and the United States Constitution. There's a little bit of complicated process with justices of the peace and such, but for the most part, the same 3-tier model applies. Now, what's different about judges in Arizona and judges in other states compared to the U.S. Constitution is how they are selected. So over time in American history, there have been basically 3 ways in which judges are chosen. The first model is often called the federal model. It's the one that I think folks are most familiar with. And this process is in which the executive nominates and the upper chamber confirms judges. So at the presidential or the United States level, the president nominates, the United States Senate confirms. In other states, governor nominates, the state Senate confirms. Generally, these are to lifetime appointments. So this is, again, the original model that was most popular at the time of the American founding. Over the course of the 19th century, most of the states began switching to elected judges. The terms were varied, but effectively judges would run in elections. These were originally partisan elections. Some states in the progressive era make these nonpartisan elections, but these are effectively a competitive election akin to a governor or a state legislature in which different candidates argue that they will be the best judge, and the voters will select one or more of those candidates to serve on the relevant judiciary, if it's the state Supreme Court. In the mid-20th century, a few states began experimenting with what was called either the Merit Plan or the Missouri Plan. It's called Missouri Plan because Missouri is credited as the state that developed the model most specifically. And this modifies the structure somewhat, in which it's trying to keep, from the perspective of the drafters of the Missouri plans, the benefits of both the federal system and the benefits of an elected judiciary. Right. One of the concerns about an elected judiciary is that they will get sucked into party politics. They'll be basically pandering to voters instead of following the law. So that's a concern. The concern with the federal model is, what do you do if you actually end up with a judge who is incompetent, corrupt, bad, lazy? Pick whatever your thing is that you think makes this a bad judge. Not criminal, but bad. And so the idea behind the Merit Plan is to basically try to avoid both party politics, but also that massive level of independence that some view as a concern with the federal model. Again, others view that as an advantage. It's the strongest guarantee of judicial independence. So the basic idea behind the Missouri Plan is that a nominating commission, which historically was the members of the Bar Association or other members of the legal profession, create a pool of candidates that they view as distinguished legal thinkers, practitioners in their state. The governor then chooses from that list. Now, again, unlike the federal model, in which the Senate would then be the confirmation, those people are appointed by the governor without having to go through the approval of the state legislature. Instead, the check is that every few years, the judges have to go up in what is called a retention election. Now, this is different than a regular elected judiciary, because in a regular elected judiciary, again, these are competitive elections in which judges and candidates are incentivized to say, that judge is bad because they're pick whatever the issue is, ruled badly, et cetera, right? There's an incentive to effectively tear down and or pull this into party politics. A retention election is non-competitive. The question that the voters are presented with is, has this judge basically done a good job and therefore worthy of keeping his or her job, yes or no? That is the single question that is presented to them, not is this other judge better? Has this other candidate promised to interpret the law in some other particular way? The retention election is just simply a, shall this judge be maintained in his or her job, yes or no? So Arizona adopted this plan in the 1960s and 70s. They sort of tweaked it a little bit. And then they tweaked it again in the early 1990s, such that Arizona is best described at this point as having a modified Missouri plan. So the Bar Association has a weaker role in the nominating commission than in other states, where the bar basically has the most powerful part of the process. The idea behind this change is a concern of, again, the idea of sort of democratic accountability, that you can elect the governor, you can elect the state senators, but the Bar Association is in effect an interest group or a guild or that nobody has elected. And so critics of the Missouri plan in its sort of purest form were worried that effectively this was overly empowering a special interest group. And so the idea in Arizona, by sort of reducing the power of the bar and the nominating commission, was to sort of reduce that power. Again, there are reasons that this was a good idea or a bad idea, but that was the theory behind making that change.
Thank you for joining us. This series is brought to you by the Center for American Civics at ASU, where we're working to make Arizona a national model for civic education. Special thanks to our content expert, Dr. Sean Byenberg, for his insights. Follow us on social media to stay connected and share your thoughts. We are on social media at ASU Civics on pretty much every platform. Don't forget to check out the show notes for any relevant links. Stay curious, stay engaged, and keep learning.